My grandmother passed 2 years ago this month, and it took 15 months for any of us to realize any of the monies and other things that were left. And I was pretty much told that's typical. 15 months, 18 months. Is that typical?
It can be, but it can be done sooner, all depending upon if your grandmother left the will and there was an executor named and they knew where everything was located.
Right.
They could literally file the will in a surrogate's court within 11 days of death and walk away with the surrogate's papers. That's what's known as probate. Now, once the executor probates the will, then they have to go about locating the assets, which is why that questionnaire, what you own and where it's located, can save time. And then the executor has to identify the value of those assets, and how long it'll take to settle the estate will depend upon the size of the estate and who the beneficiaries are. For example, if a person dies in New Jersey and their estate is not over $675,000, and if their estate is being distributed among a spouse, children, grandchildren, and stepchildren, there's no inheritance tax to pay, so they may not have to file a New Jersey return. And that, whether or not a return has to be filed and taxes paid, will affect how long it takes to settle the estate and get clearance. And sometimes, if they have a house to sell, in this economy, the sale of a house can hold up an estate as much as anything.
Sure.
And of course, if you're over the federal limit, which right now is $5,120,000, that can also determine how long it takes to get clearance. Now, what's scary and sad about what we're talking about is an estate is everything a person owns. The house, the car. If they have a refund from their apartment here at Seabrook when they pass away, that's part of the estate. Their insurance, their IRA, their stocks and bonds. But after spending an entire lifetime of working and acquiring what they have, sadly, you know how long it takes the average beneficiary to spend or consume or waste that estate?
No.
According to the American Bar, about 18 months. What's wrong with that picture? Your grandmother, and I'm not saying this is true in your family, Pete, but so many people work hard and save their whole lives, and yet the families sometimes blow through it in a lot shorter than it took for us to acquire it.
Right.
So it's good to have a plan in place. And when you're thinking about who should get what and when, you want to consider not only the size of the estate and whether or not there's a tax, but you want to look at the maturity and the competence of the people who are going to inherit it. And when we're talking about grandchildren, there's no right or wrong age, except in my personal opinion. I think 18 is too young nowadays. I think 21 is young. And in many cases, my clients have trust provisions so that if the grandchildren inherit before a certain age, whether it's 25 or 30 or 40, it's held for them, it's available for their health, their education, to buy a home, to go into business, or what have you. But my clients, the grandparents, don't want the grandchildren to get it at such a young age that it acts as a disincentive.
Right.
Because if it does, in the long run, you have to ask yourself, am I helping them or am I hurting them?
Right. That's true. Because sometimes kids end up with a bundle, and then it's party time. And they don't settle down and develop their own skills and their own disciplines because grandma's money is carrying us through. And then suddenly, grandma's money is gone.
Right.
And then we have the other issue today, unfortunately, which happens all too often, and that's the high divorce rate. Where clients will say to me, I want to leave it to my son, but my son doesn't have a very good marriage. If he inherits it, can my daughter-in-law get half?
Right.
Legally, normally, no, unless your son inherits it from you and then puts your daughter-in-law's name on it, because then he's made a gift of half the money. And clients will also say, well, if God forbid my son dies before me, should I leave it to my daughter-in-law? And there's no legal right or wrong to that except for two observations. I always kiddingly say in-laws can become outlaws.
Right.
If you leave it to your daughter-in-law, she might remarry again.
There you go.
And then your grandchildren, if there are any, may never see it.
Right.
And number two, while your children and grandchildren can inherit up to $675,000 free of New Jersey tax, daughter-in-laws are taxed at 11%. So there's a difference in tax between a child inheriting, a grandchild inheriting, or a daughter-in-law inheriting. Daughter-in-laws and son-in-laws can inherit legally tax-free up to $25,000 by New Jersey law, but over that they're taxed at 11%. So if you want to leave them a token, maybe leave them $25,000, but make sure the rest goes to your grandchildren, or if there are none, leave it to your other child, or whatever you think is appropriate for your circumstances.
Yeah, depending on the formation of your family.
And I guess one other thing I should point out, Pete and Mary, and that is putting things in joint names does not save tax. It may avoid probate, which means if a person dies and all of their assets are jointly titled or registered with them and someone else, or payable on death to someone else, that person will inherit them, even if there is a will. But putting someone's name on everything doesn't avoid taxes. Whether or not there's a tax under state or federal law will really depend upon the amount and the blood relationship. For example, no tax between husbands and wives, no matter what the size of the estate is. No tax between parent and child or grandchild as long as they don't inherit more than $675 under New Jersey law. And if it's more than that, then there's something called the New Jersey estate tax. And for federal spouses, there's no tax, but for everyone else, no matter what the relationship, there's one exemption for the whole group, and that's $5,120,000 this year. Next year, stay tuned, and if Congress does the unthinkable, which is possible, we may want to come back and revisit that, Lord willing, in the future. So just remember what Ben Franklin once said, two things in life are certain, death and taxes, but someone added a corollary, and that is at least that doesn't get worse every time Congress meets. Taxes usually do.
Sure.